Representing Public Enterprises Minister Pravin Gordhan has raised concerns over the manner in which his client received Public Protector Busisiwe Mkhwebane's notice inviting him to respond to allegations against him. Tebogo Malatji, who's responding to a YouTube video that was posted by Mkhwebane's office of her detailing the investigations against Gordhan. Well, to discuss this a little bit more, I'm now joined via Skype by our constitutional law expert, Phephelaphi Dube. Thanks so much for joining us. Welcome to the program. We've been hearing this story play out between Pravin Gordhan and advocate Busisiwe Mkhwebane, and for people who don't understand the law, it's starting to seem like a feud that's playing out over a period of time. What's your take on some of what's gone on so far?
Well, I think given the latest developments, it's obviously important to draw a distinction between the law, perhaps on the one hand, and perhaps the optics of the Public Protector's conduct. And I make this point because in terms of the Public Protectors Act, she's well within her rights to issue that particular notice. That particular notice is really part of what informs the Public Protector's investigations. And in essence, she's putting it to the individual that they may have a case to answer, and in essence she's allowing this particular individual to prepare a defense or to state their side of the story. But of course that's not where it ends. I think we perhaps need to go further and perhaps question the conduct of the Public Protector in this regard. Firstly, the fact that this was a video which was placed on social media, and secondly, the fact that neither the individual himself nor his legal representatives were personally informed by the Public Protector's Office of the latest developments. So I think that's where we should perhaps be focusing the current debate about this spat between the Public Protector's Office and Minister Gordhan.
All right, so Section 7.9 notice, I mean, essentially what it says is that we've got this evidence that we believe could be useful. What is your take on the evidence that we have? Is that what the Section 7.9 notice is?
Well, in a nutshell, that's exactly what Section 7.9 says. And in fact, there's really nothing untoward about the Public Protector issuing this particular notice. It's simply to allow Minister Gordhan to prepare his side of the story because he's an implicated individual. So it's really a procedural requirement, and it's how the Public Protector conducts most of her investigations. So on the face of it, one really shouldn't read too much into this particular use of this specific section of the Public Protectors Act. All
right, well, let's talk a little bit about, so if nothing untoward has happened, let's say Pravin Gordhan then supplies his side of the story and that the case actually then collapses, won't he have been prejudiced by going out in public and saying that this is what we suspect he's done? We've got to hear his side of the story and then we'll make a decision. Should she not wait first to hear his side of the story before making announcements? It's almost like accusing somebody of something and then only much later you say, actually, he didn't do anything.
Well, I think certainly in this regard, questions can be asked about the conduct of the Public Protector. And I think perhaps we should also focus on some of the other bigger matters in which she's been involved in, where the courts have indeed questioned the manner in which she conducted herself with regard to how she treated some of the parties who were implicated in some of her reports. So, for example, if we consider her conduct in the ABSA CX matter, the fact that she withheld some crucial information from some of the implicated parties. So again, I think these latest developments are really an indicator of the fact that the courts do take the procedure and the conduct of the Public Protector's Office quite seriously. Although, of course, I think in this instance, we should perhaps be treading lightly with regard to the particular use of this particular section, because it is a section which is used regularly. It's used frequently in the investigations that the Public Protector's Office embarks upon.
Now, former Constitutional Court Judge, Chairperson of Freedom Under Law, Judge Johan Krichler, recently says that he feels that Mkhwebane has made some strategic mistakes. Now, that's quite a big indictment from a former Constitutional Court judge. This doesn't inspire confidence.
Well, I think one would not be amiss in reaching that conclusion, especially if we have a holistic view of the general conduct of the Public Protector's Office in a few of the high-profile cases. And of course, we shouldn't forget the fact that the Public Protector's Office did attempt to change the Constitution, and yet this was a power which the Public Protector's Office simply doesn't have. So I think if we look at that in a holistic sense, and also the fact that the public protector, the fact that the courts also came down heavily on the public protector's involvement and the manner in which she investigated the dairy matter. And I think if we look at those instances quite closely, I think there would be reason to give weight to the remarks that were uttered by Justice Krichler. But I think on the other hand, if we consider her particular conduct in this regard, I think perhaps that's really something that's best left to the courts, bearing in mind that Pravin Gordhan and his legal representatives have already approached the courts for a review of this particular report.
Do you think that there are some questions that Minister Gordhan probably needs to answer, and that maybe, whilst the focus is on her conduct, maybe there might be some substance to her questions?
Well, I think having read and looked at the response that was given by Pravin Gordhan's legal representatives concerning his conduct in the Ivan Pillay matter, I think perhaps the question should then look at the particular enabling laws that within SARS that allowed Pravin Gordhan to act in the manner in which he did. And I think perhaps if those particular laws are found wanting, then arguably the public protector might have a case, because as it is, it would appear as if Pravin Gordhan was acting within the allowable scope of the regulation within SARS, and also the fact that he also had the legal opinion of the within the legal reporters within SARS. So I think if we take all of those factors into consideration, it might be difficult to suggest that there was, on the face of it, obvious unlawful conduct on the part of Pravin Gordhan.
All right, Phephelaphi, we're going to have to leave it there. Thanks so much indeed for giving us your insights, as you always do. Thank you so much indeed.